And now I will jump into some cases concerning collections. The first of which is Patch versus Hingham. Here, the taxpayer owns property in the town of Hingham that is subject to a betterment assessment associated with a sewer extension project. He brought an action in the Superior Court against the town seeking injunctive relief and a declaration that the assessments in connection with that project were void. Taxpayer is now appealing a Superior Court dismissal of his complaint, which the appeals court upholds against the taxpayer. So what happened here? At the 2012 annual town meeting, the town voted to approve a project to extend the public sewer line in the town's North Sewer District to the area of Ship and Cottage Streets. At the 2013 annual town meeting, the town voted that the property owners on those streets would bear the full cost of the project, and that the betterment assessments imposed on those properties would be calculated using the uniform unit method, which can be found in General Law, Chapter 83, Section 15. On September 3rd, 2013, the board approved the plan for the construction of the sewer line extension. The board also identified the 29 properties subject to the betterment assessments in connection with that project. The taxpayer's property is among those identified as subject to an assessment. On September 1, 2015, 2 years later, following the completion of the project, the board approved the betterment assessment schedule. On September 15, 2015, the town's Board of Assessors signed the warrant to commit the assessments to the collector of taxes, and the treasurer-collector of taxes issued a notice to the taxpayer informing him of the assessment on the property. The same day, the taxpayer initiated this action for injunctive and declaratory relief, and as we noted, judgment was entered dismissing the complaint for which this appeal is being considered. So what is the taxpayer alleging? The court identified several areas of concern raised by the taxpayer: the town's use of the uniform unit method to calculate the assessments, the classification of one residence as a single family rather than two-family dwelling, the alleged extension of the sewer into private ways, the use of grinder pumps, the failure to obtain approval for the project from the Department of Public Health or DPH, the percentage of the project paid by the town, and the inclusion of certain costs in the assessments, such as legal fees. So let's address each of these in turn. Concerning the application of the uniform unit method, the taxpayer argues that the assessments are void because the town incorrectly applied the uniform unit method by failing to impose betterment assessments on certain properties abutting the sewer extension line that had pre-existing access to the public sewer, and by classifying one two-family dwelling as a single-family dwelling. These arguments both fail. As an initial matter, the town's use of the uniform unit method was proper. The town was permitted to choose by vote any method authorized by the general laws to calculate the rate of the betterment assessments. Here, the town voted to utilize the uniform unit method authorized by General Law, Chapter 83, Section 15. The court adds that the mere existence of other properties abutting the sewer extension line does not undercut that determination. This is so because an assessment is properly imposed on a landowner, including those with a pre-existing sewer connection, only if the new sewers and discharge systems affect the landowner so as to give that landowner a special benefit. No evidence was offered to contradict the town's determination that the specified abutting landowners were not among those who received a special benefit by virtue of the sewer line extension. An interesting side note on this case is that the town had a bylaw in place that said assessments like this are required on abutting properties, whether or not they receive a special benefit. However, the court notes that such a bylaw, as inconsistent with state law, Chapter 83, cannot stand. Municipalities may not adopt bylaws or ordinances that are inconsistent with state law. The taxpayer further argued that the defendants failed to comply with General Law, Chapter 83, Section 15, by assessing one property as a single-family dwelling rather than a two-family dwelling in a manner inconsistent with the zoning laws then in effect. However, the town's building commissioner conducted an inspection of the residence at issue. Applying the definition of a dwelling unit then appearing in the town zoning bylaws, the building commissioner determined that the residence classified as a single-family dwelling. The court says there is no error with the town's reliance on the building commissioner's contemporaneous inspection. The taxpayer also argues that the assessments were unlawful because the town did not obtain approval from DPH for the project. This argument fails, in short, because the town was only required to obtain approval from a different state agency, the Department of Environmental Protection, DEP, and they did do that. Prior to 1974, DPH was required to approve sewer system plans before construction commenced. However, in 1974, this scheme was altered when the legislature created the Department of Environmental Quality Engineering, DEQE, and transferred authority to approve sewer system plans from DPH to DEQE. In 1990, the statute was further amended to reflect the name change from DEQE to DEP. The court notes that General Law Chapter 83, Section 1 still contains language added prior to 1974 that references the requirement that DPH approve sewer system plans. However, this argument is contradicted by subsequent legislation. The remaining objections to specific costs included in the assessments, including costs related to the extension of the sewer line through easements across private property, as well as for grinder pumps, legal fees, and wages for employees of the town sewer department. All these claims were determined to not be the proper subject of an action for declaratory relief, so they're not being addressed for this more technical reason. Further, the substance of such claims is that the assessments are excessive, and as we saw in a prior case, the proper avenue to raise such a challenge is through a petition for abatement. So what are the main takeaways here? DPH does not need to approve such project. That is now DEP. The town's use of the uniform unit method was proper, and assessments are properly imposed on a landowner, including those of the pre-existing sewer connection, only if the new sewers and discharge systems affect the landowner so as to give that landowner a special benefit. Additionally, further appellate review was denied in this matter.